अस्सलाम वालेकुम एवरीवन। तो आज के इस व्लॉग की शुरुआत करने वाला हूं क्योंकि आज हमारे सेंट्रल यूनिवर्सिटी ऑफ कश्मीर के लॉ डिपार्टमेंट में सेकेंड शेख नूरुद्दीन इंटरनल मूट कोर्ट कंपटीशन ऑर्गेनाइज करवाया गया है। जैसा कि आप लोग पीछे बैनर दे सकते हैं, हमारे डिपार्टमेंट के अंदर एक बड़े लेवल पर इंटरनल मूट कोर्ट कंपटीशन ऑर्गेनाइज करवाया गया है।
Thank you, dear Modassir. Actually, today the Law Society at the Department of Law School of Legal Studies, Central University of Kashmir is organizing Sheikh Noor-ud-Din Noorani second internal moot court competition. There are around 10 teams who are going to participate in this moot court competition, and whole moot court competition shall be evaluated by the external judges. We have got judges from the judiciary, prosecution, and certainly from the bar. And I wish all the students who have been participating into this moot court competition a very good success. Thank you very much.
तो आप लोगों को मैं दिखाऊंगा कैसे कंपटीशन होता है और कैसे हमारे डिपार्टमेंट के अंदर मूट कोर्ट करवाया जाता है और हमारे डिपार्टमेंट का लेवल क्या है। ये सारी चीज़ आप लोगों को दिखाऊंगा। बहुत इंपॉर्टेंट, बहुत ही इंफॉर्मेटिव और बहुत ही जबरदस्त वीडियो होने वाला है। अंत तक देखना, एक भी पार्ट स्किप मत करना। कैसे मूट कोर्ट होता है, कोर्ट में कैसे प्रोसीडिंग होती है, कैसे जज करते हैं, क्वेश्चन काउंटर क्वेश्चन कैसे करते हैं, सारा कुछ इस वीडियो में देखने को मिलेगा। अभी शाम के 5 बज रहे हैं और हमारा मूट कोर्ट फाइनल प्रोग्राम जो कोर्ट रूम फर्स्ट में चल रहा है, मैं आप लोगों को विजिट दिखाऊंगा।
With the permission of your lordship, shall I begin the statement of jurisdiction? Much obliged, lordship. One of Cream Code A presently appeared on behalf of the petitioner.
With due permission of the bench, the council would like to present the remaining issues and the arguments.
It raises a substantial suspicion against that person. And in that eventuality, the authorities do have rights. There are citations, there are judgments on this point that the authorities do have rights once substantial suspicion develops. And once repeated summons are issued and there is no reply, there is no resort to such summons, then such measures which have been adopted in this case by the authorities can be taken. What's your point on this? What's your take on this?
Sir, definitely there are cases and there will be suspicion on the Mr. Milling that he is not complying with the summons, but he is our acting chief minister on day and out. He of a same, the official replies were given to the court.
तो आप लोग देख सकते हैं शाम के 7 बज रहे हैं और इवेंट हमारा एज़ यूजुअल चल ही रहा है और यहाँ बच्चे भी काफ़ी अच्छे बैठे हुए हैं और मैं बाहर का व्यू दिखाना चाहूँ आप लोगों को। तो देख सकते हैं क्या शाम हो चुकी है, ज़बरदस्त हमारा डिपार्टमेंट लग रहा है और एक अच्छे व्यू, इसी के साथ हमारा इवेंट एज़ यूजुअल चल रहा है।
Gravity of the offence in the present case. What other aggravating circumstance could have been taken into consideration and accordingly refused the bail of the concerned person?
That he may outrage the public during the witnesses, which may then deny from
That is the point.
Yes, sir.
You were cogent, coherent, comprehensive, persuasive, panoramic, inclusive approach for this program. Without your presence, this wouldn't have been possible at all.
And thereafter, meanwhile, Mr. Miller, he challenged his arrest before this honorable court, alleging that it is the illegal arrest and because it is arbitrary on part of the AD. If your lordships are well satisfied with the summary of the facts.
Of interim bail and as stated that the interim bail has not been defined in the code. However, it is a part of legal vocabulary. It means the temporary release of a temporary release of an accused from the custody given the pending resolution of his regular bail application under compelling circumstances.
There were apprehensions that the CM will influence the prosecution witnesses. Or there you had some proofs on the point that he has in the past he might have influenced the witnesses, or in future he is having some kind of command or control over the prosecution witnesses.
When he is the same of a party, there exists command authority. Whatever is being done by the party, there is a presumption that yes, CM knows what his party is doing, what every person in his party is doing. Command authority suggests that. Thus, there's a greater responsibility lies on the shoulders of the CM that if there are charges against
The CM know what a person is doing at his home in his personal capacity because he is the CM.
not in the personal capacity, but at least in the official capacity. He is a representative of the people here. He has to work round the clock.
To arrest a person, madam, they have to comply the essentials of Section 19 of PML Act. And their statement is completely silent on the fact what was in their hand. So, madams, on that count, they affect the personal liberty of the petitioner, madams. Madams, the other thing is which need to be taken into consideration is the timing of the arrest, madams. 9 summons were issued. Nothing was in the hand of the respondent. Just before the elections, the ED made a search in the house of this petitioner, found nothing in their hand. But why would you not respond to this? Madams, we gave our written submissions. Being a holder of the constitutional chair.
But notice was for appearance, not for the written.
Absolutely, madam. Notice was for appearance, but the reasons are different. But the essentials of Section 19 were not complied, and merely does not comply. The summons does not give the right to them to arrest me.
Team G, please.
1943. It requires that a conviction founded on a credible evidence. This standard, it is beyond the mere suspicion. And it is imperative that the arresting officer's subjective opinion should be based on the comprehensive and objective analysis of all the materials.
To campaign for a particular election while you are under arrest.
The Council would like to draw the attention of this Honourable Court towards the opening lines of the Moot proposition, which state that India is a parliamentary form of government, and in a parliamentary form of government, the political rights, that is right to vote and right to contest election, are core principles. And this Honourable Court has held in Kyoto Holomo vs. Achilo, AR 1993, SC 412, that democracy is the basic structure of the constitution and the rule of law and free and fair elections are basic features of democracy.
Investigating officer under the Code of Criminal Procedure.
For the matter, he has to
effect an arrest right at the time.
For the matter, he has to get the warrant from the magistrate, madam.
You are having the search warrant.
Madam, we don't need that, madam. Under Section 18, we are empowered to arrest.
Who is empowered? Which officer is empowered? Which officer is empowered? Show that.
Director or deputy director for that case.
No, a difference on that. Sorry, I just understood it. What I'm saying that in bail application under PMLA, the burden of proving the guilt is burden of proving the innocence is on the accused, rather than proving the guilt by the prosecution. So again, while giving the public prosecutor an opportunity to oppose
On this accused.
yes, sir, I'm saying that burden of proving his innocence is on the accused.
How come?
Because the section 45 clause 2 itself says. It says that where the public prosecutor opposes the application, the court is satisfied. There are reasonable grounds for believing that he is not guilty of the offence. Court has to be satisfied that there are reasonable grounds, not only grounds, reasonable grounds that he has not committed that particular offence under PML.
तो अभी बजे है रात के 7 और अभी हम लोग कैंपस के अंदर हैं और ख़ूबसूरत सा नज़ारा, खूबसूरत से व्यू के बीच हम लोग मौजूद है यहाँ और काफ़ी मज़ा आ रहा है और फिर भी हमारा इवेंट लगभग फाइनल होने वाला है, ख़त्म नहीं होने वाला है।
Misinterpreted the section of 45, because the two conditions that are provided in the 45 are provided in clause 3 and not clause 1, that is the opportunity of the public prosecutor to present his case. The two twin conditions are in subclause 3, that is he is not guilty and he will not commit the offence. But the contention of the respondent is that the public prosecutor was not given the opportunity to present his case, which is neither provided in the facts and is neither based on the real occurrence.
How these 2 days is exemplary. third point is, trust me, I prefer to remain silent here because I was so impressed by the presentations of my students. I could not believe that, these are the students to whom I had interaction in the class or outside class. All of, as my colleague, as my student rather has said, that all of you have done exceptionally well here, all of you. And I was engrossed throughout this presentation and in the presentations which my students made. It was an extraordinary performance so far as their confidence was concerned.
तो हमारा इवेंट फाइनल हो चुका है और अभी हमारा रिज़ल्ट का अनाउंसमेंट होना बचा हुआ है और ये कुछ डिपार्टमेंट का मैं व्यू दिखा रहा हूँ क्योंकि मैं ले चलूँगा अंदर, क्योंकि अभी रिज़ल्ट के अनाउंसमेंट होने से पहले एक छोटा सा म्यूज़िक का इवेंट रखा गया है। उसके बाद रिज़ल्ट के अनाउंस होगा और हमारा 2 डेज़ का मूड कोर्ट कंपटीशन ख़त्म हो जाएगा। तो ये बाहर का व्यू है, रात काफ़ी हो चुकी है, ले चलते दिखाते हैं आप लोग।
Moot court competition, that is Sweb Samad, Sheikh Akib and Ubaisa Amin. Miss Fiza Asad, Miss Matia Khan and Miss Komal Gupta. Ladies and gentlemen, applause for the Mr. Modassir, General Secretary, Law Secretary.
And a wonderful audience. Very good evening to you all. It's my proud privilege to propose a vote of thanks on the culmination event of this 2-day Sheikh Noor-ud-Din Noorani internal moot court competition.